but you'll put together and provide it in Word format, then that's what I'm asking you to do. Now, Mr. Tran, it being nearly 1:30, I propose not to adjourn, at least not before 2:30. But having said those things, two matters. My present understanding is that you are content to proceed today, subject to instructions, which is a matter that you can inform me about now or later if you want. But I'm not going to bring the matter back until you've had at least an hour, unless you want some further time beyond that, say 3 o'clock. The other matter, which perhaps your junior Ms. Wooten can assist the court with via email to myself and counsel on the other side. If you have in contemplation taking the court to a series of documents in the evidence or a series of authorities, I'm not going to tie you down to how you want to frame your submissions, but if you would be assisted by me being informed in advance of things you would like to commence addressing, then I'd be very happy to know that, if that's something you want to do, and you don't have to do it.
Your Honour, can I propose this course? And of course, Your Honour will hear from Mr. Wood and Mr. Holdenson whether they have any submissions about this. What I would suggest, if Your Honour is minded to allow me to do it, is if I could speak for perhaps up to 30 minutes to get us to 2 p.m. The purpose of that is, I think, to make some comments about where I'm actually going and to highlight in my respectful submission what are some of the key issues for Your Honour. In the course of that, I will attempt to make some submissions about what some things might be non-issues, and I'll also highlight a few authorities. And then if you could take the adjournment at 2 o'clock, I think the utility of taking that half hour will help frame for Your Honour.
That's a very helpful suggestion, and I see Mr. Holdenson and Mr. Wood assenting to that suggestion. I'm very grateful for it. Thank you. Please proceed.
Thank you, Your Honour. I'm going to start using this short 30 minutes by addressing paragraphs 3 and 4 of the reply submissions, and then charting for Your Honour how it is I propose to deal with ground 3, and then after adjournment I'll actually do that, deal with ground 3. If Your Honour brings up the reply submissions from very early this morning and goes to paragraph 3, and Your Honour will read there, and this is my gloss of it, but of course Your Honour can read it. It says there, my gloss, that the applicant was pressured during that transcript that Your Honour has read. Can I be crystal clear that Your Honour can rely on that submission and that evidence to find as a fact that the applicant felt pressured? Of course, I haven't sought to cross-examine the applicant. But can I make it crystal clear that what Your Honour can't do is find that any officer intended to pressure him? And Your Honour will appreciate the difference there. And Your Honour, I do.
Look. I will tell you immediately. If you understand that I have a very great desire to engage with counsel in a fairly Socratic way, so that you can remind me squarely when you say Your Honour's going down the wrong path, you need to listen, and this is something you might be assisted by. Now, the point you make, the distinction between any positive, affirmative desire to impose pressure is just something I can't make a finding about. You needn't worry about that. But as to the evidence of a subjective belief, there is that evidence and you accept that.
Yes, thank you.
That's good. Thank you.
I'm grateful that Your Honour has expressed, Your Honour, in the way that Your Honour has. So I don't need to paragraph 3. It makes good my submission that in the end, actually, whether or not there is a law requiring a person to be vaccinated to enter Australia or to have an exemption is beside the point. And to make additionally clear, I don't say this to say that Ground 1C at the threshold or anything like that. Of course, I'm going to have to deal with Ground 1C. As it's been put by Mr. Wood. But I did want to make that clear because Mr. Wood has said it orally and then said in writing, and therefore I take it the applicant considers that to be important to their case, and we say it's not important given the way that the grounds have been framed. But can I also say this, Your Honour? There is at least one provision that exists on the statute books that permits the executive, the Commonwealth Executive, to control who may enter and remain in Australia, and that is, of course, Section 1161EI itself, the very provision exercised here. That provision does not present a high bar. Can I just go to 2 cases only in this half hour, Your Honour, because then I can clear this away and not have to deal with it this afternoon at all.
Thank you, really, that would be useful. Just hang on a second. What's the first?
The first one is in the supplementary authorities that we provided this morning. I apologise.